Good afternoon, everyone, and welcome to our Reconnect virtual roundtable, which opens our fall 2020 webinar series. With us today is Michal Šimečka, MEP and Vice President of Renew Europe, as well as Rapporteur of the draft report for an EU mechanism on democracy, the rule of law and fundamental rights. The report, which builds on a 2016 resolution of the European Parliament, aims to mend the EU's fragmented toolbox to enable systemic, objective, evidence-based and legally binding monitoring of Article 2 values, developing a common rule of law standards in a single mechanism. We also have the pleasure to welcome three leading scholars on the rule of law in the EU, who will share their assessment and analysis of the draft report. Kim Lane-Skepperly, who is Lawrence S. Rockefeller Professor of Sociology and International Affairs at the University Center for Human Values at Princeton University, Petra Barb, Visiting Professor at the Central European University, and Laurent Pech, Jean Monnet Chair of European Public Law at Middlesex University. In the final part of this webinar, we will take questions from you, the audience. So please write to me through the GoToWebinar chat box to send your questions, which we very much look forward to. So we will start with an introduction to the draft report by Michal. Thank you very much for joining us today, and you have the floor.
Thank you very much, and it is a pleasure to be here, and I'm really thankful for the opportunity, also because it's rather timely, given that it was today that the LIBE committee, the Civil Liberties Committee of the European Parliament, adopted this report with a fairly overwhelming majority of 51 to 14, which I'm very happy about. Obviously, it still has to go to the full plenary in October, but it's well on its way with the majority comprising the full spectrum from the GUE, the far left, to the EPP. Which also shows that in the European Parliament, rule of law, democracy and fundamental rights is indeed an issue that cuts across political groups, and there's a strong consensus behind this. Now, let me, as a sort of a way of introduction, I probably don't need to spell all the troubles facing democracy and rule of law in the European Union. Most of you are well aware of what's happening in Hungary and Poland. Of course, there are challenges, to use a euphemism, in other member states as well. Most recently, Bulgaria is being discussed rather extensively, and the background for this report is not just that the situation is deteriorating on the ground in several member states, but also that the European Union, for almost a decade now, has been unable to address it in any sort of coherent, let alone a systemic way, which would have resulted in some progress. We all know that the Article 7 proceedings against Hungary and Poland are going nowhere. We see that in Poland, the government and the courts are blatantly disregarding the rulings of the European Court of Justice. So all of this brings also the European Parliament to the issue of how to address this in a more coherent way. Before I say something about the report and the mechanism that it envisages, let me stress, because this is important, that I think by now everybody's aware that the strongest possible tool that we have to fight authoritarian politics and corrupt and oligarchic governments is the money, and is the conditionality that's now being discussed as part of the Next Generation EU and the MFF. This is a strong demand by Parliament, by myself, by our political group, and this is sort of, I treat this as a given, that we all somehow are now aware that without the threat of removing control over the disbursement of EU money, without the conditionality, we're not going to move forward. But I mean, even with this enforcement in place, I still believe that in the long run, we need a proper monitoring system and a coherent monitoring system, an objective monitoring system, to establish democracy, rule of law, and fundamental rights as a core EU agenda that is integral to its business. And this has been the problem until now, that we have lots of tools to address rule of law shortcomings, but they are A, weak, and B, they're all over the place, and it's a bit of an institutional chaos. And what my report aims to establish is to streamline and consolidate the various tools we have, to establish a clear set, or to put forward a mechanism to establish a clear set of benchmarks against which rule of law, democracy, fundamental rights will be assessed, and also to make it clear what kinds of violations would lead to what kind of consequences. I think the first point I'll go over the points one by one. The first point about streamlining, and I think this is absolutely crucial, because many of you will know that apart from the Article 7 proceedings, apart from infringement, we have at least 5 or even more different tools in the EU. We have the rule of law framework, that's the Commission's tool. We have the rule of law dialogue in the Council. We have the CVM for Bulgaria, Romania. We have the Justice Scorecard, which measures the performance of justice systems, and obviously we have all sorts of things, but they are kind of disconnected. And what we aim to establish with an annual monitoring cycle at the heart of all of EU's rule of law agenda, with the annual assessments, annual reports, to be kind of a centerpiece of all of these, around which all of these other tools will revolve. That's one point, and that's I think one of the key aspects of this report of mine, in able to sort of integrate and streamline all of these tools. For instance, the CVM for Bulgaria and Romania, there might, after we have a proper functioning annual monitoring cycle, we might not even need many of those other tools, because they would be superseded, such as the rule of law framework or the CVM for Bulgaria and Romania. Now, the other I think important aspect of this report is that it would reinforce what we have today. And the problem with the tools that I've spoken about is that many of them are, and this is well known, I mean, many of them are rather weak. Because the legal basis for them are weak, except perhaps for Article 7, but there the hurdle is pretty high, as we all know. But even infringement proceedings, even all the rule of law framework and dialogue, they have a very weak legal basis, which is also one of the reasons why my proposal aims to put the monitoring mechanism into an interinstitutional agreement between the Council, the Parliament, and the Commission. Because although obviously in the long run it would be ideal to change the Lisbon Treaty to insert a stronger rule of law protections, but in the absence of that, an interinstitutional agreement would serve as a fairly strong legal basis that could be taken to court for all the 3 institutions to act in protection of the rule of law. I think this is also what makes my proposal, or our proposal, the Parliament's proposal, different from what the Commission is doing in its annual rule of law monitoring, which will be presented later on this month. The weakness of that is that it's just based on a Commission communication, which is again a very weak basis, and it also is going forward largely because the Commissioner in charge, Didier Reynders, is obviously committed to these issues. And because now we have the German presidency, so the stars are, so to speak, aligned. So we might actually have the rule of law report discussed, but that's not going to. That's not solid enough. This is why we're pushing for an interinstitutional agreement, because there, if one or other institution, say the Council, would be dragging its feet on action on the rule of law, they can it can also always be challenged in court. And the final crucial thing, crucial aspect in which the report that's been adopted today in Libe makes for a stronger tool, is that it expands the areas which are to be monitored, because the Commission is still focusing rather narrowly on the rule of law, that is, on the independence of the justice system mainly, right? Because that's the biggest problem in Poland. They're also, to some extent, focusing on corruption and on media pluralism, but obviously this is not the only thing that's problematic in countries like Poland or Hungary. It's often a bigger blend of issues, including fundamental rights and democracy. And Poland, unfortunately, has witnessed, an escalating rhetoric of hatred, for instance, against minorities, against sexual minorities, and all of this is part of the same political context. And I think it's good to look at it in such a political context. Therefore, any monitoring, we think, must encompass the full scope of Article 2 of the European Union, which all of these values are listed. So to perhaps conclude, our report aims to establish annual cycle of reporting in which the three institutions would cooperate, in which the Commission would be charged for drafting the reports, but they would be discussed by Parliament, by Council, and each institution would be required to do its part by an interinstitutional agreement. It would cover all three, democracy, fundamental rights, and rule of law, and it would specify, the interinstitutional agreement would specify what are the consequences should there be persistent and systemic failure. For instance, one of the consequences could be the withdrawal of EU money. The other consequences could be the triggering of Article 7, but it would be specified in that document, and those reports would be the basis for action through the other tools that we already have at our disposal. One final thought, and this is where I began. I think the problem is not only the lack of enforcement, which clearly is a problem in the EU, but also that we still treat in the EU and in the European politics, we still treat rule of law, democracy and values as something taboo, as something which in the Council, for instance, should not be discussed openly because it's too sensitive, because it offends people's sensibilities. The problem is that we have in say the Eurozone or in any other economic field, member states are far from shy to castigate each other for failing to adhere to debt requirements or have too high deficit or are not implementing structural reforms. They're very critical of each other, but when it comes to the rule of law, everybody's like, we shouldn't touch this because it's too sensitive. And we want, and through this report, we want to establish democracy, rule of law as central and part and parcel of the European political agenda, because it's unacceptable that the EU, with its regulatory power, can speak to and regulate the ways your bulb what kind of electricity goes into your bulb and what shape does it have, but doesn't have to say, but is not saying anything about whether your journalists are being imprisoned or whether your judges are politically subjugated. So I think this is the overall long-term aim. Thank you very much. I hope I wasn't too long.
Michal Šimečka, thank you so much for shedding some light on how the EU has in many ways fallen short of addressing rule of law, and not only rule of law issues thus far, and explaining the rationale behind this interinstitutional agreement, which, as you said, revolves around streamlining the current tools, reinforcing the tools that are available, and expanding the focus. I would now like to invite our panel of experts to share with us their thoughts and comments, starting with Professor Petra Bard.
Very much. I hope I unmuted myself correctly. It's a pleasure to be here again. Let me jump to the text immediately that has just been adopted, and let me praise it for a number of reasons. And the first reason I praise it, as opposed to other instruments and other proposals, it tackles the problem of the rule of law together with democracy and fundamental rights. So it realizes the interdependent and triangular nature of the three parts and the core values enshrined in Article 2 of the Treaty on the European Union. The second reason I praise this is that it dares to call a spade a spade. So we've been in this research group long been propagating for the usage of the right legal framework. If a problem in the national setting is a rule of law problem, it should be named as a rule of law problem too. A perfect formulation of the problem is already half the solution in law, and vice versa. Asking the wrong legal questions inevitably dooms the outcome of the case. So when targeting individual issues, it is more difficult to recognize the systemic attacks against the rule of law or fundamental rights. And the proposal allows for bundling cases using the terminology by Professor Šimečka, even though she suggested it in a different context. And it allows for seeing the network of interdependent and mutually reinforcing problems. The third appraisal goes for the proposal or for the text already adopted, because it doesn't buy the counter arguments against EU action, such as, these are internal national matters, it's better to keep certain member states inside than outside at any price, and so on and so forth, which are very easy to be attacked and to counter. But let me come to a rather powerful counter argument, namely that the EU doesn't have the power to act, to enforce its own values. And Mikhail, you already debunked this myth in your last sentences. Of course, a departure from the rule of law or from democracy has EU-wide consequences for the whole EU project, not only because members who are not elected in a fair procedure are participating in the EU's lawmaking process, thereby legitimizing the whole exercise, but also because rule of law problems become contagious. And also the EU stance toward third countries as a promoter of democracy, the rule of law and fundamental rights will lose on its legitimacy if it will not be hypocritical, if it cannot tackle its own internal issues. Also, the document takes the time element into account. Of course, each and every government should be given sufficient time and space to present its arguments, but the dialogue part of the instrument is only workable, or the sunshine approach, as some in the literature say, is only workable if the parties share the same values, they speak the same language, they use the same vocabulary. There is no reason really to prolong deliberation, discussion, and debate once it is clear that the member state is not open to share the same language of constitutionalism or liberal democracy. The document should also be praised for an equal treatment of the member states. The patchwork nature of current instruments has the drawback that there is a cherry picking of the instruments on the side of the institutions and also on the side of the member states. Another reason that I like the text adopted is that there is a regular scrutiny that is proposed. So the EU wouldn't have to wait until things escalate and there is such an amount of backsliding or gross human rights infringement that an Article 7 procedure has to be initiated, or even an infringement procedure. But the whole document takes this precautionary principle approach. Once there is a problem, it can be highlighted in due time so that there can be a U-turn if a member state is departing from the path of Article 2 values. Also, the proposal could be, it's not very clear from the document, but it could be EU law specific. So if a member state has already breached the values, the EU wouldn't have to wait for external players such as the UNHCR or the European Court of Human Rights or CPT or the Venice Commission, or you name them, but it could rely on its own system. Also, it could establish higher standards than required by external fora, such as the Council of Europe, that includes member states with very poor human rights and rule of law records. Also, the EU could take EU law principles into account and act promptly whenever there are violations or potential violations. Again, I emphasize the precautionary nature of the document. So if there are potential violations of Article 2 values, then the presumptions and the legal instruments and institutions that are at the core of EU law could immediately be suspended, such as mutual trust, direct effect, and so on and so forth. Now, when it comes to the actual text, there is some room for debate as well. And now let me just highlight certain points in the document, and I will focus on Annex 2, which really is the core of the document adopted. So the three institutions establish a permanent interinstitutional working group on union values, which will be entrusted with facilitating coordination and cooperation among the three institutions in the annual monitoring cycle. Here the question is, in which entity will be entrusted with carrying out the actual analysis of the domestic situation? Because here the language is coordination, so the working group only seems to coordinate cooperation. The working group also is requested to invite the Fundamental Rights Agency and consult independent experts on a regular basis, which is very welcome, but it's a little blurry to say that the agency and the individuals are consulted. It is also unclear to what extent the working group is required to rely on the findings of the Fundamental Rights Agency and the experts. Also, it's a good idea to include other entities such as the Venice Commission, Greco, UN, or the OSCE. You don't have to reinvent the wheel, you don't have to do redundant work. But again, as I said in my introduction, the EU element should be emphasized, namely that there are certain EU law concepts that these entities and institutions cannot, because they must not, because they don't have the mandate to monitor. So of course this EU-specific working group should focus on these parts of the EU law. Now, one of the greatest challenges is the selection of entities and experts to the working group. The selection process must be made autocracy-proof, otherwise the annual report will neither be impartial nor based on objectively complied evidence, as it is actually required by the document itself. The selection of the procedure must be an incredibly careful exercise, ensuring that at the minimum government-funded so-called NGOs or fake experts are not invited, or that their assessment, it can actually feed, I think, into the discussion, but it should be considered as an alternative formulation of the government's position. The gist of the matter is the response prong of the whole mechanism, or the follow-up. So with regard to follow-up, in order to give a bite to the mechanism, the Commission should not only be given the option, but should be obliged to request institutions to enter into a dialogue with member states when problems occur and are identified, with the aim of facilitating the implementation of the recommendations that are also formulated in the framework of this system. It should also be acknowledged that Article 7.1, as it currently stands, is a preliminary procedure itself that allows for a dialogue. It's not a nuclear weapon. It really is the tool of a debate between the institutions and the member states. So one should be careful about treating this whole mechanism, or not treating it as a preliminary step that would be needed to instigate an Article 7.1 procedure. So in other words, it shouldn't be a preliminary Article 7.1 procedure in the end of the day. At several points, the document talks about an urgent procedure which can be initiated and conducted irrespectively of the annual report. This is particularly important, but as the Court of Justice cases show, such procedures need to be accelerated, expedited, they need to be prioritized, and they only will function effectively if interim measures can also be imposed. And finally, there is a proposal to suspend EU law concepts that are based on the presumption that every member state is a state based on the rule of law, respecting democracy and fundamental rights as well. This is very welcome. We've been proposing this for a long time. Let me only add that when doing this exercise of evaluating Article 2 in light of mutual trust, mutual recognition, direct effect, principle of supremacy, we could have higher standards than the Council of Europe. And what is also important in the end of the day, in this regular exercise, one could also pinpoint at the time when mutual trust and the other legal concepts should be reestablished when a member state returned to the European family and to the values enshrined in Article 2 TEU. I stop here for now. Thank you very much.
Thank you so much, Petra, for this, I think, very in-depth assessment, pointing to the strength, but also some areas, some questions, and some areas for development that we will definitely go back to in the discussion. I will now give the floor to Professor Laurent Pech.
Thank you very much. I agree with every single point made by Petra, so I'm just going to try to build on the points she has already made. I propose to go through, essentially to structure my presentation around three main points, or set of points rather. I'm going to highlight first the positive aspects of the draft report and the draft agreement. And then I'm going to highlight some areas where I actually disagree with the report and the mechanism. And then I'm going to end my presentation with some potential dangers, not really about the content of the report itself, but how the report might be used, or rather misused, to justify inaction today, in the name of action tomorrow. But let me begin with the most positive aspects of the report/mechanism from my point of view, not repeating the already positive points raised by Petra. So I think the first positive aspect of the report is that it does essentially, as Petra said, call a spade a spade. It's very clear on the nature of the crisis we are facing. It is unprecedented. It is escalating. So that's the first positive aspect. It doesn't shy away from the reality on the ground. So that's first positive aspect. Second positive aspect, I like the fact that it does correctly stress the rise and entrenchment of autocratic tendency and state captures in several EU member states. That's good. I think that's the first time I've seen the concept of state capture being used in EP resolution, but I could be wrong. But this is very good. This is spot on. Another aspect which is positive in my view is the criticism directed at the Council regarding several areas, and especially the way they have made Article 7 proceedings even less effective than the text allows. So this is very important. Yes, there is a lot of criticism about the high thresholds when it comes to decision-making procedures within Article 7, but in fact the Council has made a very heavy process more ineffective through a number of, I cannot get into the details, but essentially, just to give you a concrete example, they have excluded the EP from presenting and defending its reasoned proposal at the Council, in my view, in violation of EU primary law. There was no need to exclude the EP from Article 7 proceedings, and the Council did so, obviously, just to make it even less effective than it could have been. Also in agreement with the suggestion made by the MEP to go beyond the rule of law. Yes, I would say we have Article 2 TEU, we should simply have a mechanism related to Article 2 values. I understand, however, why the Commission is starting modestly focusing on the rule of law, because essentially there is a lot of case law on the rule of law. So I guess it's easier for the Commission to build on the case law and to try to defend the case law, existing case law of the Court of Justice. But we need to go beyond the limited scope of the first edition of the forthcoming annual report. Also welcome in my view is the call for specific country recommendations, clear timetables, targets, effective follow-up, and also concrete actions in case of non-compliance. So this aspect is particularly welcome in my view. A lot of the shortcomings we are experiencing today has to do with the lack of effective follow-up. I cannot go into details, but there are a lot of judgments of the Court of Justice which are simply not complied with, and the Commission is just ignoring the lack of compliance. I can give you plenty of examples later during the discussion, but we have clear examples of ECJ judgments being violated in plain sight with no reaction. So we need follow-up and we need concrete action in case of non-compliance. I also like the emphasis on judicial independence. So judicial independence is described as being of crucial importance. So I think that's a crucial point, well made by the report. Also, plenty of concrete recommendations which are very welcome in the report, such as the need to protect human rights defender, the need to create a new pan-European statute to better protect associations and non-profit organizations. So this is very welcome. The need to expand the mandate of the EU FRA, the need for strict budgetary conditionality. All of these points are excellent, are well made and spot on in my view. I also like the section on follow-up, which is actually, I think, very good. But slowly but surely, I'm going to then move on to my areas where I slightly disagree with the report. So the follow-up section is good. I liked the sentence asking for EU member states to justify non-compliance, or rather, how they comply with rulings of the Court of Justice. So that's particularly good in my view, because the Commission on a number of fronts is not doing its job in terms of punishing member states when they don't comply with ECJ rulings. So we need the Parliament to get into the picture here to make sure that the follow-up is properly done. However, there is possibly, in my view, overemphasis on dialogue. As you know, my personal position is dialogue is always the autocrat's best friend. So the last thing we want to do at this stage is to create a new dialogue window. That's the last thing we need at this stage, is to give those violating EU values more time to actually consolidate their violations on the ground. So I would say possibly the paragraph about dialogue needs to be beefed up if it's not too late, to avoid creating another dialogue window. So we have so many dialogue windows that it's difficult to count them very quickly. But Article 7, paragraph 1, for instance, as Petra mentioned, is actually nothing to do with the nuclear option. It's more or less another structured dialogue. Let's stay away from possibly creating another dialogue window. Also, I disagree with the diagnosis about the toolbox, which is made in the report. The report does say that the Union remains structurally ill-equipped or lacks effective tools to enforce respect for shared values. And I would have to disagree here. I agree with certainly the need to improve enforcement. I agree with the need to streamline the toolbox, but the issue is less the toolbox than the way the toolbox is being used by those who should know better and who should do better. You did mention infringement action, but in fact, the infringement action has a very solid legal basis. There is no issue about the legal base as far as infringement action is concerned. And infringement action can be very effective if properly used and proactively used. So nothing to do with the toolbox here. It's everything to do with the fact that the toolbox is not properly used and promptly used. I've been following rule of law development for quite some time, and the toolbox has always been used as an excuse to justify inaction today in the name of better action, more meaningful action tomorrow. This has been always the same song being sung every year for the past essentially 10 years since the Tavares report. We have heard the toolbox excuse regularly coming back. So I would say possibly, yes, there is room for improvement regarding the toolbox, but the EU can do a lot on the basis of what it's got. I do agree, however, that yes, EU funding, this has not been properly used to contain democratic and rule of law backsliding. We cannot go into the details. I think the Union can do a lot already in terms of suspending EU funding on the basis of the legal existing framework. But the draft regulation now being discussed certainly would be welcome, because it's quite clear about rule of law, the type of examples which would justify EU funding. So to that extent, you could argue that the draft regulation now being discussed about conditionality mechanism is a positive step in the right direction, because it does provide with more legal certainty about suspending EU funding when it comes to generalized deficiencies as regards the rule of law. But my key point here is the toolbox as it is today can be more meaningfully, promptly, and proactively used, and would do a lot of good if used in this way. A more minor point regarding the CVM, the Cooperation Verification Mechanism, as regards Bulgaria and Romania. I think it would be seriously ill-advised to actually, on the back of adopting the new mechanism, actually just repeal this cooperation verification mechanism. The two countries, Romania and Bulgaria, their authorities do not deserve to be rewarded with the end of the CVM, when in fact, not only have they done close to nothing in terms of improving judicial independence, they're actually backsliding now. So I would think that removing the CVM at this stage will actually send a very bad, poor signal, and is not actually necessary. It could be used as a complement for the time being, coexisting with the proposed mechanism. Potential dangers now, just to finish my presentation. So I have described some areas where I disagree with the report, and now I'm looking beyond the report to see how it might be misused by those not interested in actually doing anything meaningful in the short term. So the first danger is that a lot of actors are going to pretend to be interested in adopting this proposal so as to justify inaction in the short term. So instead of focusing resources, limited resources on launching more infringement actions or discussing how to actually suspend EU funding right now, we're going to spend a lot of time discussing the best possible mechanism, which will then never been used. And then within a year or two, we're going to start discussing another mechanism, another new tool, because the toolbox doesn't work. But it's nothing to do with the proposal itself. I'm just saying about the politics of the toolbox. It's something we need to keep in mind. Also, I think there is a danger that that the ambition is good to essentially oversee the situation in all the member states, but we should not treat the law-abiding citizens and criminals alike. So it's very important that we don't use this permanent monitoring mechanism to actually send the signal that what's happening in a number of countries is similar or just the nature of degree. Just to give you an example, we are now in a situation we have at least one EU member state which is no longer a democracy. So there is no point subjecting this member state to the same mechanism as democratic regimes. This is not a nature. This is not a difference of degree. This is a difference of nature. So it's important that this new mechanism does accept the reality we are facing, which is we have at least one and soon two EU member states which do fundamentally violate the basic of EU membership conditions. Also, I think, so I did say about the dialogue window. Let's avoid creating another dialogue window if at all possible. What we are missing in the short term, so I agree that this is so essentially my bottom line here is that this mechanism is a good long-term solution. However, possibly let me end on this key point, is that it's not going to help solve the situation, for instance, in Poland with the judges, independent judges being persecuted, harassed on a day-to-day basis. So we have to make sure that in the meantime, the Commission is being told, as the Parliament actually did last week in the resolution about the situation in Poland, that the Commission does fulfill its duty as guardian of the treaties. There is a lot of good which can be done in terms of containing the situation by launching infringement actions. So we need to tell the Commission to stop serving us with excuses regarding legal basis or lack thereof, or just the Court of Justice being allegedly overloaded with cases. We need more infringement actions, and we need infringement actions right now. We also need the situation to be more seriously monitored. I'm talking about the situation in Bulgaria. Just 6 months ago, in the last CVM report regarding the situation in Bulgaria, I read the report, and then it felt like I was reading something about Alice in Wonderland. Nothing to do with the reality on the ground. So there's something which needs to be done also about who does what in terms of overseeing the situation. And possibly, let me put it in a different light. The proposal is a good long-term solution, but we have to accept that we are now in a situation where the barbarians have breached the gates. So the barbarians are no longer outside the gates, but they are within. They have breached the gates. They are within the compound now. So this is something very important in terms of how the proposal that you have put forward, Michal, might be actually captured from within. I think to that extent, I do agree with the point made by Petra, for instance, regarding the panel of experts. We have to make sure that this is not going to be captured from within by a number of fake experts. In Poland, the ruling party has been appointing fake judges. Now we have to be mindful of them not corrupting the EU processes by appointing fake experts. So long story short, a very good proposal, a very good long-term proposal. In the short term, however, we have to be mindful that this is not going to be used as an excuse not to do anything when what we need is political and legal actions in the short term in terms of in order to contain and penalize those who deliberately violate the values on which the EU legal order is based. So thank you very much.
Thank you, Laurent, for this also very thorough assessment. I would now ask Professor Kim Skepperly to share her thoughts with us as well.
Great, thank you very much. I always love to hear my name pronounced in Dutch fashion, so this is great. Anyway, so first of all, I want to say that, for 10 years that the rule of law has been on the agenda of the EU. The Parliament has always been out in front of all of the, when you compare the Council, the Commission, and the Parliament has had a terrific track record. It's recognized problems in real time. It's passed resolutions that were really called for in the moment. I think that, when the history of this period is written, the Parliament's track record will look really good. And I think this proposal is in keeping with that track record, which is to say, I think that the Parliament, as represented by this proposal, is again sort of out in front of all the other EU institutions and thinking about, what an ideal monitoring mechanism would look like. So this is meant to be, a congratulations to Michal and to the Libe Committee, because I do think this is really an extraordinary step forward. But of course, we wouldn't be having this if we were all in agreement. So let me just say a few things. One is that this is an ideal proposal for 1990, which is to say, it's an ideal proposal for before when these issues arose, which isn't a reason not to do it now. I mean, it's always possible to catch up to the ideal of the past, I suppose, but I share a little bit the worries that Laurent just expressed, that once a new mechanism goes onto the table, it takes all the attention away from actually fixing the problem in the present. So let me just say just something very quick about sort of the history of thinking on this. So the reason why I say this is a perfect proposal for 1990 is that what was, of course, on the table in the Amsterdam Treaty was the first mechanism for sanctioning member states, which is what's now Articles 7, 2, and 3, which was the other member states would rise up and they would condemn the rule of law violator and impose sanctions, and that would be it. So then the first time that there arose a real challenge where this might actually be used, which was with the Austrian case, the reaction of all the EU institutions was to amend the treaties to say, well, that was too strong. What we really need is a warning stage. So hence what's now Article 7.1 was born. That sat there until we got the Hungarian case, at which point the Commission was like, well, I don't think we can really, ask for Article 7.1 because we don't have the information. So what we need is a preliminary mechanism, and hence we got the rule of law framework. Okay, so then Poland came along, the rule of law framework was actually used. It hasn't been effective. We've had 10 years of rule of law deterioration in the EU. And now along comes, the rule of law monitoring mechanism that the Commission is supposed to be, coming out with later this month, in which the solution is not to go deeper on the states that are problematic, but to review every single state so that nobody can claim there's double standards, right? So in other words, and then this proposal comes along, which broadens it and includes all three institutions. Okay, so the reason why I say that is that there's been a tendency every time there's a problem to enlarge what has to be done before any action can be taken. By bringing in all the states, by bringing in all the institutions. And so I think this is an ideal proposal in the sense that this is what always should have been there. And I hope eventually it will be there. I think that's not a reason not to start it now. But it does mean that in the face of every single concrete challenge so far that the EU has experienced, the result has been to add more stages before anything can be done. Right, so that's my worry. But let me say a couple of things about why it's still, I think, important to press forward with this framework. One is that one of the really important elements of this, which Mikhail said earlier, is that so far we've all been rather stuck on the idea of rule of law and judicial independence, which are crucial, and really probably the front line of attack, on what these rogue member states are doing. But pretty soon we're going to have to get to the question of what happens when member states are no longer democratic. this year the Varieties of Democracy Project classified Hungary as no longer a democracy. What do you do about that, given that the democratic deficit in the EU has always been remedied by the reliance on democratic procedures in the member states? What happens when you have member states that are no longer democratic? And what if you get member states that can no longer guarantee fundamental rights, as Michal said? So all of the values of Article 2 need to be in the framework. And this is where I think this proposal is really visionary, because no one's gotten around to thinking yet about how we enforce the other EU values. And this might be the right mechanism to put into place for when we have to broaden out beyond the rule of law where we are now. So the worry is that this proposal is so good that I'm afraid it will attract all the attention and get everybody's mind off where we are in the present. So let me say a couple of things that I'm worried about. So first of all, it does make perfectly rational sense to start folding in all these additional mechanisms from CVM all the way through to the justice scoreboard, which by the way has always been useless. For example, if you're going to measure the quality of the judiciary by the speed of proceedings, the fastest proceedings are kangaroo courts, right? So in other words, you don't really get much quality of judicial review by simply looking at speed, and the justice scoreboard really focuses on indicators of that kind. But I think that there, in an ideal world, you'd fold all these mechanisms into one. This is not an ideal world, so I'm really worried about getting rid of any tool we have, on the theory that you might get a commission that might use something even if the council doesn't agree. You might get the parliament being able to, call out and shame the commission for not acting, and so on. So in other words, by folding everything into one mechanism, it kind of invites everybody to go into one process, and for that one process to be hijacked somehow, right? So redundancy is really good if you're worried about capture of one part of the process or another. And I think we've already seen capture, in some of these processes. So I think for now, redundancy is good, and the aspiration to eliminate redundancy is probably a mistake. The other thing is that, I started by praising the track record of the Parliament, which I mean really genuinely. And what I'm worried about with this mechanism is that the Parliament is putting its energy into pushing the other two institutions along from inside, from a stronger position, which again, I think perfect mechanism in the ideal. Sometimes Parliament's biggest effect over the last 10 years has been to hold hearings, to call out countries, and to pass strong resolutions that shame the other institutions. And I hope Parliament doesn't think it's losing that power, because the power to call out and shame and provide sort of oversight, public oversight on the council and the commission, I think has been one of Parliament's most valuable tools. And I hope Parliament doesn't think this is a substitute for that. Again, I'm actually in favor of more redundancy at this moment rather than less redundancy. A third thing is that, I think it's important, like one of the important aspects of this proposal is that it puts in place a kind of consistent and continual monitoring mechanism. But as Petra and Laurent both said, at some level, we're way beyond monitoring. Like, everybody knows what's happening in Hungary. Everybody knows what's happening in Poland. Another diagnostic doesn't actually fix it. So this leads to the next question. How do we actually fix things in these member states? We can call it out, we can shame it, we can punish it. But it seems to me that the punishment or the measures taken by the EU ought to have something to do with how the problem gets fixed. And that's not, this is beyond the scope of this mechanism, but I do think we have to start thinking about that. So one reason why I've been pushing conditionality of funding for, goodness, since 2012, I guess, is because the funding is actually going to prop up the governments of these states. And they can discretionarily allocate this funding to their friends and fix problems with it, which keeps them in power. So cutting the funding to the member state actually, cuts a pin out from under their support, which may actually weaken their ability to stay in power at home, It may strengthen the opposition if you can find ways to get money to independent sources around the country. That would actually go some way toward fixing a problem. And that's why I think conditionality is even more important right at the moment for the rogue states than monitoring. And finally, my last comment is that it's very interesting how, although we talk about legal basis, and again, one of the strengths of this is that it's has a firmer legal basis for action by all three of the institutions. But I'm always surprised how much we leave out the Court of Justice here. There's no role for the Court of Justice. And actually, with the Parliament, the Court of Justice has been the most dependable institution in terms of coming up with concrete ways to fight the rule of law. This judicial independence jurisprudence that the Court of Justice has put together over the last couple of years is nothing short of remarkable. And they've shown themselves to be open and willing to enforcing the treaties, including the values. So at some point, and maybe that's a different proposal, that I think the Parliament needs to find some way to encourage cases to get to the court. We have various mechanisms for getting to the court, the most obvious one being infringements. Maybe the Parliament should try to, call out the Commission on the fact that the Commission is now bringing half as many, or maybe less than half as many, infringements as they did just 10 years ago. And they tend in these cases, particularly in the case of Hungary, to miss all the crucial elements and bring infringements against really quite marginal things. So, figuring out how to get more cases to the court strikes me as a really promising immediate mechanism. So as you can see, my general kind of diagnosis here is that this is a great proposal for the long term. This is what should have been there all along. That means that it's important to keep working on it. And I think this is the comprehensive mechanism that should have gone in place with the Treaty of Amsterdam as soon as the possibility of rogue states emerging in the EU really got onto the political agenda. So in that sense, I think this is terrific. That said, I think it was Laurent or Petra who said the house is burning now. So the question is, do you design the ideal fire department, for nationwide in order to fight the fire happening in the house now? Or do you also work on a parallel track to figure out ways of solving these immediate problems? And there, I think, as most of you know, my big, focus has been on trying to push the Commission to bring infringement actions, to frame them more broadly, to frame them more systemically, because I think the court is open to actually ruling in these kinds of cases. And there are very good sanctions mechanisms attached to failure to follow court decisions. So I hope the Parliament won't give up its historic role of shaming the Commission into action, of calling out the Council for failing to do anything at all, because I think that the voice of the Parliament in elevating these issues has been one of the most effective devices over the last 10 years. And I hope the Parliament also continues to work on this proposal. So thanks.
Thank you, Kim. Thank you so much. I think it's now time to go back to Michal Šimečka for his response on these points, which have ranged from what the permanent working group within this mechanism should look like, and the risks surrounding the involvement of experts and the selection process of those experts, the risks of creating a preliminary step to Article 7, which were raised by Petra Barb, which tie into the criticism of Laurent with regard to an excessive focus on dialogue within the draft proposal, and is differing diagnosis when it comes to the existing toolbox, rule of law toolbox within the EU, and the importance of maintaining certain mechanisms such as the CVM, for example. And then, of course, the politics of let's say, the tendency rather to enlarge what needs to be done before taking action, which was one of the points raised by Kim, and also the importance of focusing on how to practically fix the problems that Poland and Hungary, for example, are facing. And finally, also a role for the ECJ within this context. Michal, the floor is yours. Your microphone is off. There you go.
It works now, huh? Can you hear me well? Good.
Yes.
Well, first of all, I want to say a huge thanks to all of you for taking such time and to sort of analyze the report and for giving such penetrating and perceptive criticism, and I'll focus on responding to the critical parts because they are also the most interesting and they are the ones that move us forward. But before I hope I'll be able to cover most of them. I've wrote down the notes, but before I'll address the kind of the overarching concern that there is and that's sort of hanging over our discussion and was mentioned by all of you basically, and the fact that this is not a proposal to fix the immediate and alarming situation with the barbarians already broken into the into the gate and with the fire, the house already burning, and I absolutely agree. And here I have to say that I absolutely take that concern, it seems to me that it's an issue of sort of managing expectations of this particular report. And I had an interview recently with a Hungarian, one of the few remaining Hungarian media outlets, and they've asked me, is this going to help the situation in Hungary in any way? And I said absolutely not. And this is unfortunately the way it is. This is really for the long term, and designing something that once it's up and running and working should prevent such deterioration, in some other member states, and should put rule of law, democracy, and fundamental rights at the core of the EU's everyday agenda, make it in a way normal. This is kind of the long-term aim, and I absolutely take the point that it's not going to fix the situation today. And this is what should be our urgent concern, and where should we focus our resources. I wouldn't worry that much that this particular proposal would kind of divert attention or political capital or anything from the main issue of the day, which is the budget conditionality, because it sort of, from what I observe in the European Parliament, and this was the worry or the concern raised also, that the European Parliament might be by proposing this interinstitutional agreement, might be becoming too cozy with the Council or the Commission. It seems to me that the Parliament is really putting its foot down on the budget conditionality and on the regulation that's on the table, including on the reverse qualified majority for that to be triggered. And this is irrespective of whether this particular mechanism, how long, whether it's going to fly or not. I think this is a central demand of at least my political group, and I personally will not approve an MFF without budget conditionality. And I think this is on everyone's mind. So, and alongside that, we have this preventative, monitoring mechanism, which is also there. But I would be worried that it's taking away too much attention. But that same goes for, and I should say that as well. That's again been the concern that we should, or that's been one of your points that kept repeating, and that's about the infringements. And I absolutely take the point that obviously, if fully utilized, then the infringement proceedings in that bundled shape are an extremely powerful tool, which the Commission is underusing, and obviously have a sound legal basis. I should correct myself there. And we've the Parliament, as in the case of budget conditionality, is pretty firm on that. We've been criticizing the Commission for not acting, not bringing more infringement proceedings, for taking too much time to do it, for not moving on with say fines in the case of Poland, for disregarding the ruling of the European Court of Justice. We have put it into the report on Poland, which I've been shadow rapporteur for my group. So I'm just to reassure that Parliament is on that as well, and hopefully will stay true to the tradition that Kim has spoken of defending in the strongest possible term the core rights and values of the European Union. So, but bottom line is, you're absolutely right. This is not meant to fix the crisis that we have at the moment. This is meant to be a long-term mechanism and solution. And I will also be the first to guard against anybody trying to misuse or abuse this so that, and by anybody I mean the Poles and the Hungarians, and perhaps the Bulgarians in this case, or somebody else, to misuse this particular instrument to say, well, we have now, we have this monitoring, we don't need to care much about Article 7 or infringements or whatever. I actually been also in the European Parliament, in the plenary, whenever I have an intervention, I've made it clear, always talking about this instrument and this mechanism, that it's not an alternative and not a substitute to the instruments that we have, namely Article 7, and of course infringements and budget conditionality. That it shouldn't sort of detract from that. But I guess, I mean, always there's, I think, might always be the danger that the other guys will try to misuse that, but I don't think it should be a reason for us not to press ahead with this alongside what we have at our disposal already. Now, I'll try to take the points one by one on the role of experts and the working group as an entity. It is a bit unclear in the draft text, and I take that it's a bit of a deliberately left unclear, and the details not spelled out, because this is something that you might want to be kind of finalized in the negotiations of the draft interinstitutional agreement, not to kind of have it up already with all the details up front, including where should the working group secretariat be housed and all that. It's been also somewhat amended, and I don't know if you have the final version voted in committee today, because there's been some amendments pertaining precisely to the working group and the role of independent experts, and how these independent experts will actually function. The final compromise agreement between the main political groups is that the working group, which will comprise the representatives of the three institutions, will have sort of an overall steering coordination role. The institutions accountable and responsible for drafting and producing the final material will be the European Commission, because that's what it's supposed to do also under the treaties, and that's what it's also begun doing this year. And the panel of independent experts will be attached to the working group and advising on throughout the monitoring cycle. The selection of these experts is not written in stone. I take the point that we should guard against infiltration, so to speak, or corruption from the inside. I think that's a good point. But on the whole, it will be the Commission in charge and responsible for coming up with the final product, and will be held accountable as such by the Parliament and by the Council. I think the important thing about having an additional sort of entity or an additional layer of independent expertise in that is those people will be public and could, for instance, be called onto the European Parliament to testify, as in sort of a parallel exercise. If the European Parliament deems the Commission's reports to be weak or inadequate or lacking, we can always call on somebody from the independent expert panel to actually appear in say a Libe committee and put things straight. So that's I think a bonus, or in my sense, it improves the design. On the creating another window of dialogue, that's Laurent Pech's point. I think that's well taken, and I might actually have a look at the draft before it's voted in committee, and perhaps we can think of an amendment before it's voted in the plenary. My sense is that I guess you always need, I mean, I know that this is it's difficult, but you always need to give the government in question a certain space to respond. I think that's even if it's an authoritarian government like Hungary's, and we know that they're going to be just using it to stall the entire process and to consolidate whatever power grabs they have embarked on. But I think it seems to me that that's unavoidable. What we could do, and I wanted to do originally, but that's very controversial, is perhaps just make it clear that, and this is again touching on Petra's point, I think, that Article 7.1 could be precisely that kind of dialogue that could be, the first follow-up to a report of this annual cycle criticizing rule of law, democracy, fundamental rights developments. And I think this is a very good point. I think to normalize Article 7.1 to make it that it's not the nuclear option, but it's absolutely okay to talk about problems when it comes to the rule of law or indeed democracy, fundamental rights among member states on the basis of these reports to trigger Article 7.1. And I think so perhaps that could be the window, that could be the dialogue window that's now referred to in the annex of this report. But I actually can have a look and think if there's a way of amending it to make it kind of authoritarian proof before it goes to the plenary. On Bulgaria and Romania, again, this has also been covered to some extent through the amendments, also my amendment, where also in light of what we have seen over the past few months in Bulgaria, I think the final wording is that the CVM should be replaced once Bulgaria and Romania have satisfied the conditions of the CVM, which in effect basically leaves it as it is, because it would have ended had they satisfied when they satisfied these conditions anyway. So that's kind of taken care of. On the point, very interesting point about relativism, in the sense that this mechanism would treat democracies and non-democracies alike. I think that's a very strong point, but at the moment I can't think of a way to go around that. As long as they are member states of the European Union, I don't see how we could have a special regime for Hungary or any other member states which would descend into non-democratic territory. And I think I'm afraid that it would have to be the same standard for everyone. Although I take the point that this is in a way unfair because it's simply a different category of regime. But it seems to me that that's unavoidable. Other points, yeah, if redundancy is not actually beneficial in these cases, I think some redundancy obviously some of these instruments will of course remain in place, even if this proposal is adopted as it stands, which again is still a long way off. Infringements will stay as they are. Article 7 will stay as it is. Hopefully budget conditionality will be there. The only redundancies that we're trying to kind of perhaps get rid of is the rule of law framework. Because once you have this, really, what is the point of having a rule of law framework? Because this is it in a way, right? Or this is the second stage, or the second stage of this report will be the rule of law framework. The same thing is with the rule of law dialogue in the council. There should be, and if there is an interinstitutional agreement, will mandate that the council discusses these reports. This by itself is controversial in the council, that these reports of the monitoring cycle should be the basis for discussion in the council. But once this is the practice, then we really don't need a separate format rule of law dialogue in the council. That seems to me just a technical consolidation. Yeah, we covered the CVM. I think the justice scorecard, if we're looking at the independence of the justice system in the monitoring, I think the scorecard should very well be a part of that, because as you say, it's not really used as a stick, but more as an accounting exercise, basically. Yeah, so this is, but the key tools will remain in place, which the Commission can use at its discretion, or which the other two institutions can use. Yeah, is the Parliament not going to get cozy with the Council? I definitely not. Of course, we want the Council and the Parliament and the Commission to start negotiating on this basis, but obviously, having a strong, budgetary conditionality is way more important to Parliament. If I could put it in these terms, because everybody's aware how critical it is to actually put out the fire that, as you say, is already burning in our house. I hope I've answered some of them. Some of the concerns, those which I've not, I do apologize for. There's one final thing which I wanted to touch on, and this is the democracy part. And I think this is perhaps where it's going to be the most controversial, to expand the scope to cover democracy and fundamental rights. But I absolutely agree with the point on democracy that Kim has made, that this is becoming a huge problem when you have non-democracies as EU member states. And it's becoming a problem for the legitimacy of EU decisions, and especially for decisions in the Council. For me, I'm a Slovak citizen, say, and I don't have any, the EU doesn't have any control over how national electoral processes are conducted. So it actually violates my rights in a way if Hungary or any other member states chooses its political leaders in a non-democratic way, because those political leaders will decide on laws that affect me because they are members of the European Council or of the Council itself. So I think this is a huge issue that over the long term will become more and more apparent, and this is also what we wanted to capture. Yes, I think I'll stop here and wait for other questions. If I forgot to pick up on any of the other criticism, I can get back to them.
Thank you, Michal, for addressing all of these points so thoroughly. I would like now to bring in some questions from our audience. We have, first of all, Professor Dmitry Kochanov, who suggests the idea of obliging the Commission to bring cases rooting in the findings of the monitoring mechanism. And he questions whether perhaps involving the court more deeply as part of the proposal right away could be the way forward. And then we have a question from Valentin Pluchard, who asks instead, considering the wording of the report, is it well-founded to fear that the complementary nature of the annual monitoring cycle will be a way for the most reluctant actors to relegate this new mechanism to an evaluation tool for the sole purposes of Article 7 TU? We then have Max Stewer, who wonders to what extent you envision the interaction with and support for pro-democratic civil society actors. Is there room to enhance the space and support these kinds of actors? Redemocratization is highly unlikely to occur without strengthening domestic actors who face unfair rules of the game. And perhaps we can add also a question from Petra Giongi, who notes how previous mechanisms also operated on the basis of giving recommendations, and even in the follow-up stage. However, this approach proved to have pitfalls in the past and remains prone to political manipulation. How would this be overcome beyond setting specific targets and timeframes? I think the floor can go back to Michal, and then anybody else who would like to comment from our panel can also join the discussion.
Yes, thank you very much. I'm muted, right, good. Well, thank you for the questions. On obliging the Commission to bring infringement action on the basis of the reports, and this is something that was discussed. I think it's in a way also, given that any interinstitutional agreement would have to be subject to the approval of the Commission and the Council, I don't think this would be realistic, but my thinking about this was that we should leave the Commission as much discretion in a way as possible when it comes to infringements, because there was also an idea in that the annual reports would be the sole basis for any action taken by the EU institutions and by the Commission specifically, be it infringement, be it Article 7, be it budgetary cuts. And this was my original idea, but then I thought that this actually would be limiting the maneuvering space of the Commission, because they would want to and should launch infringement proceedings at any point, even on issues which are not addressed perhaps, or when we're waiting for an annual report and we have to react urgently. So I think obliging the Commission to act only on the basis of these reports would be or sort of constraining its ability to act. It could be possible to the other way around, and to say that if there are violations, serious rule of law violations found in these reports, then the Commission would have to bring action The problem is that there are it seems to me that there are differences in that one is a political document, the other one, it's a different matter whether there's a legal case for infringement action. Although in these reports it would be made clear in the assessment that this is a problem, be it in the judiciary or be it anywhere else, but it would not necessarily meet the threshold of infringement. So this is why it stays as it is, but it's definitely something worth considering. What we would like to, and what I think is spelled there quite clearly, that it would that there would have to be follow-up, and that there would have to be specified consequences for identified failures or for failures identified in these reports, without saying that the Commission outright saying that the Commission has to bring an infringement proceedings because there are simply too many different situations that could arise. And I forgot to address this before, why the court is not involved is because simply the Parliament or the three institutions can't quite in this way involve the court in their interinstitutional agreement. And it's the same with other bodies of the European Union. We can't say in our own agreement that the court should do this or the Fundamental Rights Agency should do this, because this is an agreement between these parties. I'm not a lawyer, but this is my understanding of it, that we can't quite commit other institutions or other bodies to do something. That's kind of my non-lawyerly understanding of it. What extent do we envision the involvement of democracy activists and different actors also in the member states? I think that to the widest, it seems to me also in the making of this report, I've consulted a wide range of experts, of activists, including FRA, including the various NGOs at the European level, also at the national level. And I think and I hope it's spelled clearly enough also in the report, in the resolution, that they should be one of the key sources of data for the production of these reports. And I think they already are in the exercise that the Commission is doing this year, and I hope that they have been consulted. Obviously, there's the issue of funding, and I think here there's a proposal, and most of you are probably familiar with this, that when it comes to budget conditionality, it doesn't have to be only framed in negative terms. It could also be that whenever there's a problem, the money could be redirected to fix that problem in a way that it could go to municipalities, NGOs, good governance projects, all of this. So this is also one way of using EU instruments to actually help those fighting for democracy. And also, obviously, they should be part of this annual monitoring cycle. I think that's absolutely clear. And then there was a question which if I may paraphrase. I mean, to what extent? What happens if member states fail to follow up on the recommendations within the given timeframes in the annual reports? Well, I mean, this is again the problem of enforcement. I think this is definitely at that point it should be in my view, it should be the Article 7.1 or infringement proceedings if there's a clear failure to comply in the relevant time frame with the specific recommendations of these reports. Obviously, it will be named and shamed in Parliament and hopefully also in Council discussions, and the immediate consequence, legally speaking, should be Article 7 or infringement. Yeah.
Thank you so much, Mikhail. I know Kim unfortunately needs to leave us for another commitment. Any closing words from you before you leave us?
Yeah, sorry, it's not just any other commitment. I actually have to teach a class in about 7 minutes. So if I could just say a couple of things. I mean, one is just in response to Dimitri's question about mandating the council, mandating the Commission to bring infringements. I mean, I think probably the standing of this body is that can't happen, but it does seem to me that one way that this proposal might be strengthened is by having the possibility of strong recommendations to both the Commission and to the Council, right? So trying to think about one output of this process being to tee up what an infringement should look like, That's a little reminder of my class, by the way, what an infringement should look like, and providing the documentation so that it will become apparent when the Commission drops the ball. So that might help then the Parliament to shame it. Ditto with the Council. So, you know, technically speaking, the Commission is not usually the initiator of an Article 7.1. I mean, it can do what it just did this time, which is to recommend to the Council that, you know, Article 7.1 be or 7.2 be initiated. But again, one of the things that this process could do is to recommend that Article 7.1 be initiated. So in other words, what this could do is to support concrete recommendations that funnel it into the existing sort of strong mechanisms. And finally, my point about the court was not to bring the court into the compact. I agree that that's impossible. But I'm wondering whether this process couldn't generate information, evidence, or encouragement for cases to be brought by various actors, either infringement cases by the Commission or other actions in national courts that might result in references, you know, where the data for those cases would come out of this process, which is another reason why the transparency of these processes may be crucial, because they could lead to cases that would eventually get to the Court of Justice. And that just thinking about the connection of this mechanism that you're proposing, Mikhail, with like, so what comes later? How does this funnel into and strengthen the existing processes might be a good, you know, sort of way to think about how to strengthen it. Thanks. And I'll duck out in another minute or two, but I'll stay as long as I can.
Great, thank you, Kim. Perhaps I can give the floor back to Petra.
Sure, thank you very much. Also on Dimitri, I think obliging the Commission to start infringement procedures, or actually having an automatic triggering of any other procedures, whether it's an Article 7 procedure, an MFF procedure, or whatever, is really at the core of the issue, and it would solve a number of problems. It would take away the political edge if there was an automaticity inserted into the system by the DRF Pact. But I think that has not yet been inserted in the Interinstitutional Agreement that was adopted today, or the Parliament's version. Max, there is you talk about an interaction with civil society actors, and I think this is very crucial. The document places a huge emphasis on civil society actors and their selection. Now, my proposal would be to actually confront the government with what civil society is saying. So if the shadow report has a totally different understanding of the situation on the ground in the member state than the actual report by the government, then there should be a shift in the burden of proof. So it's not necessarily the working party or the Commission or whoever who should do this exercise and figure out who is right, but it should be, in quotation marks, an accusatorial adversarial procedure where the government should have to prove why the civil society's assessment of the situation is incorrect, if it is incorrect. And then, of course, another question emerges as well. What should we do with the assessment of civil society or think tanks or experts? Michal, you mentioned the invitation of experts into the European Parliament, but will their assessment be also published, or will it appear somewhere as a quasi-dissenting opinion, and so on and so forth? So these are of course crucial questions. But burden of proof, the reversal of the burden of proof would to some extent solve the issue. And finally, Petra, previous mechanisms such as the rule of law framework that work on the basis of dialogue and debate, well, they prove to be rather unsuccessful, I must say. Of course, we can distinguish scenarios where there are systemic problems in a member state, such as, for example, corruption or lengthy procedures or heinous prison conditions. But if there is a willingness on the side of the government to adhere to Article 2 values and to do something about them, then it still makes sense to have this dialogue. This is what pilot judgments are there for in the context of the Council of Europe. And it's a whole different scenario when a country already abandoned the path of democracy altogether. Then it doesn't really make sense to have further discussions, further recommendations, another deadline, and so on and so on. And the application of the rule of law framework vis-a-vis Poland proved that there is no reason really to presume the good intentions of those in power to engage in a sunshine approach involving a dialogue and soft measures to make an entity return to the concept of limited government, a notion that those in power wish to abandon in the first place. So when, Michal, you talked about the possible abandonment of the rule of law framework, I think we wouldn't lose much on the way, and we should stick to the measures that really are very clear. They are equally applied to all the member states. No one is singled out on the basis of geopolitics or whatever size or whatever reason. And also that have a dissuasive, effective, and proportionate sanction at the end of the procedure.
Thank you, Petra. And finally, Laurent.
Our time is soon up, so let me be brief. I'm just, let's not talk about the report, but I just have some concrete, practical, short-term suggestions, possibly that we could explore, or the European Parliament could explore further. Something I've never fully understood is why the EP is not intervening in pending ECJ cases as a third party. So my understanding is that according to the rules of procedure, the European Parliament will only join pending cases when the interests of the European Parliament are at stake. So by interest of the Parliament, mostly, I guess, institutional interest. But what about amending the rules of procedure to allow the legal services of the European Parliament to actually step in any Article 2 TEU related pending case before the ECJ? That would be actually something not very difficult to do, I think. And that would be actually very helpful to actually express publicly before the Court of Justice the position of the most democratic EU institution. I would say, why is this not done? I have never fully understood. I've been asked around for the past year or two, and it seems that it's just because the rules of procedure do not allow for it. But then the rules of procedure are not the Bible, they can be amended. So possibly that's something short-term which can be done, and we actually be very welcome. Let's say regarding today, we had a hearing in Luxembourg about Polish judges being persecuted by Polish authorities. It would have been nice to see lawyers from the European Parliament emphasizing the importance of judicial independence in these two pending cases. I would say also in terms of transparency, there is a lot which can be done this time by the Commission, and possibly the European Parliament could push the Commission into being a bit more transparent about infringement actions. For instance, why the Commission is not yet back to Luxembourg to ask for daily penalty payment against Polish authorities for them due to them violating the order of the Court of Justice of 8 April 2020. Generally speaking, I think the Commission is not should justify itself more regularly when it doesn't pursue infringement action properly. Sorry, there is a lot of echo here. I'm just saying that we don't quite know, for instance, when the Commission doesn't apply for interim measures. So it would be good to know more about when the Commission doesn't pursue a case or doesn't apply for interim measures, just like a one-page press release with some key legal arguments. So regarding Hungary, for instance, it's very difficult to find publicly available information about why they're not pursuing Hungarian authority regarding media pluralism in the context of EU competition law. There is two pending state aid law applications which were submitted to the DJ competition. We still don't know why there is no action in this respect. So is the issue an issue of legal basis? I don't know. I would say more transparency would be good, and we don't need really to reinvent the wheel here. Also something I think the European Parliament possibly could investigate further I'm not actually clear about resources given to the Commission. My feeling, but I have yet to study this further, is that the Commission does not have enough resources to actually pursue infringement actions. So possibly it would be nice if the Parliament could ask the Commission, do you have enough staff? Do you have enough lawyers to actually do your job as a guardian of the treaties? My understanding from talking to people is that a lot of resources are being diverted to the production of the annual rule of law report. But does that mean that there are less resources for actually investigating infringement actions? I don't know, but that would be something interesting. We always talk about mechanisms, but we never talk really about resources and staff issues, which I think is quite important. And last point, I think there is, again, I guess I keep talking about infringement actions, but because I believe it is underused and it is the most effective tool in the toolbox. My understanding is that the Commission is yet to set up Article 2 infringement task force. When you talk to the Commission, they tend to, there is kind of a silo structure. Essentially, you have data protection people, you have judicial independence people, you have media pluralism people. But possibly because of the nature of the threat and the multifaceted nature of democratic and rule of law backsliding, the time has come to set up transversal infringement teams specialized in Article 2 matters. Because I think there is a lot of very high-level technical knowledge in the Commission, but possibly they don't always talk to one another to have the transversal picture. So you have teams working on data protection in Hungary, for instance, but they may not be talking to the people knowing about judicial independence in Hungary. So I'm just saying that possibly there are plenty of practical considerations to be looked into in the short term, in addition to actually the streamlining of the toolbox as you have helpfully suggested. So thank you very much.
Thank you so much, Laurent. We are all but out of time. Perhaps I can briefly give the floor to Mikhail Šimečka before we bring this panel to a close.
Okay. Yeah, well, I just to finish with a huge thanks to everyone who participated, but specifically, of course, to, and most importantly, to Petra, Laurent, and Kim for their perceptions and really kind of pointed criticism and comments, which at some point I was almost sorry that I wasn't able to have this discussion before we put it to the vote. No, thanks so much. Also for the suggestions that Laurent made at the end. I think there's definitely, and I will be the first one to admit that there's a lot to do, which is apart from this report, which focuses on the immediate situation, which focuses on putting out the fire in the house burning, which has to do with action, which has to do with resources, which has to do with the EP getting more involved in the particular cases. And I absolutely agree. And I would also talk to colleagues about some of these suggestions. But alongside that, we're also going to be thinking long term, and that this is what the report is for. Again, thanks so much for your critique and for the discussion. And I'll be looking forward to some other opportunity to have this debate.
Thank you, and that is all the time that we have for today. I would like to thank our audience, as well as our speakers, of course, for this great opportunity to discuss such pressing issues in this pandemic-proof setting. If you would like to know more about the Reconnect project, please follow us on Twitter at ReconnectEU and visit our website at reconnect-europe.eu, where we will be sharing updates on our upcoming webinars. From Michal, Kim, Petra, Laurent, and myself, it's thank you and goodbye.